We'll get started in about a minute or two. I just want to give enough time to allow everyone to sign in to be able to listen to the webinar all at once. Just some housekeeping issues. If anyone is having issues either hearing or viewing the presentation, if you could go ahead and utilize the chat feature, I'll type in a test message. This will allow me to obviously figure out the issue. Hopefully I could fix it. I don't anticipate it being a problem viewing or listening to the presentation. Like all of our webinars that we host, they will be residing on our website, this one specifically next week. I usually allow for about 5 business days for us to upload this webinar to our website. And then there you'll find about 10 other webinars that we have done throughout the years on various topics relating to employment background checks. Well, I guess we could go ahead and get started. It is 10 o'clock on the West Coast. So good morning to everyone on the West Coast and good afternoon to everyone on the East Coast and in between. I want to thank all of you for joining us today for our webinar titled What Employers Must Know About Medical Marijuana. We selected this topic because currently, especially in the state of California and 18 other states that we will obviously discuss in the presentation, this is a very hot topic, and employers must know what their rights are, what applicants' rights are, and who is responsible, who can be held liable if your employee has a medical marijuana recommendation or was prescribed or recommended medical marijuana by a doctor. So again, if anyone's having issues with the audio or video, please type in a message in the chat feature. If you have any questions throughout the presentation that come up, please put them in the chat feature as well, or you could email them to me. We'll go ahead and answer as many questions as we can at the end of the presentation. The presentation should run no more than about 40 to 45 minutes, so there should be ample time at the end of the presentation to go over any questions or concerns. This is one of many webinars that we hope to do this year. If anyone is passionate about a certain topic or has a question about anything related to background checks that you may want to see in a webinar, please by all means email me, give me some suggestions. I'm always seeking feedback because we want to improve on these. We want to be able to offer these at no fee. So with that being said, as many recommendations as you guys could have would be much appreciated. So we can go ahead and get started with the presentation. Again, this recording, and if anyone would like a copy of this PowerPoint presentation, by all means send me an email. I'll be more than happy to share it with you. But like I mentioned, this will be posted on our website next week. So if you do miss the presentation or have to cut out early, you could view it in its entirety once it's on our homepage. So again, this is our webinar today titled What Employers Must Know About Medical Marijuana. And my name is Cody Farzad, and I am the Vice President of Employers Choice Online. And I've been in this role for about 1.5 years now. I've been with the company in total about 6 years. And my main responsibility and what I'm passionate about and what I like to do is educate employers on employment background checks. It's a very, very dynamic, fluid industry. Laws are always changing. So in order to be an expert, in order to be trusted by clients, I do as much as I can to research current case law, future case law in each state. Obviously, I like to consider myself well-versed on the Fair Credit Reporting Act, and that is a federal law which regulates what consumers or credit reporting agencies can and can't report, and you will get a better understanding of how the federal government really does kind of trump all other states with regards to background checks, especially with regards to medical marijuana. Certain states do have certain laws, for instance, the use of medical marijuana, so it's very important that we stay up to date on not only federal law, but also states out there that regulate employers on what they can and can't do with regards to background checks. For instance, Colorado just came out with a law regulating employers' use of credit reports, and that's following in line with about 9 other states that are regulating credit reports, and I foresee a lot more states jumping on board and regulating employers' use of credit reports. But that's for another time. Let's go ahead and get started with the presentation. This is our disclaimer. By all means, we recommend consulting with your employment or labor attorney when making any kind of employment decision. We will definitely be able to assist you through the background screening process and interpret your report. But if there is any gray area, then of course we always recommend our clients to consult with their attorney to see what their rights are. What you will learn today. So we'll go over the background on medical marijuana, kind of the history. It does have a very, very long history that we will dive into. I will also go over the original purpose. What was the original purpose to even enact or have medical marijuana laws? We'll, of course, go over states that currently have medical marijuana legislation. We'll discuss the federal government stance on it, which is pretty black and white. We'll talk about maintaining a drug-free workplace. Also talk about drug testing programs and policies. Synthetic or fake marijuana. This is very, very new. However, it's rampant, and it's a very, very dangerous drug that we'll talk about. We'll even go into case law in California, Federal District Court in Ross versus Raging Wire Telecommunications. This is kind of a precedent case that set the foundation for any kind of future litigation with regards to medical marijuana. I'll talk about the 2 states that have legalized marijuana altogether, Washington and Colorado. We'll go over current trends, preventions, and then recommendations that we will have. Okay, kind of a background on medical marijuana. Started back in 2737 BC, so there is an extensive history on this topic. Actually, Chinese emperors would prescribe marijuana in a tea form, if you will, for the treatment of gout, rheumatism, malaria, and even poor memory. Also in the 18th century, American medical journals recommended hemp seeds and roots for the treatment of inflamed skin and even venereal diseases. So you see that throughout our history, marijuana has always kind of been recommended or used in treating certain illnesses. In 1914, the Harrison Act formally made drug use a crime. So anyone that abuses any form of drug considered a drug from the U.S. government would essentially be convicted of a crime. Also, California is the first state to legalize marijuana in 1996. Also, these states passed Marijuana Tax Act, which made marijuana illegal for non-medical use. So as you'll find out throughout the presentation, marijuana use is still illegal through the federal government. And so it really doesn't matter what states say in the end. If the federal government recognizes it as illegal, then it is a crime. But we'll get into that in further detail. The original purpose of medical marijuana was to permit individuals with severe and debilitating medical conditions be able to purchase medical marijuana under the recommendation. That's a recommendation, not a prescription, of a medical doctor for therapeutic use. So an individual would visit a medical doctor, would let them know what their issue is, if they have cancer, if they have a debilitating injury, whatever the reason is. And then the doctor, being a medical doctor, will evaluate that individual and determine if they should give them a recommendation for medical marijuana. Medical marijuana has established effects in the treatment of, so it's been able to assist individuals with nausea, vomiting, lack of appetite, migraines, and even sleeping disorders. So for cancer patients that don't have an appetite, that's losing weight due to medication, and they just don't have the desire to eat, marijuana could aid in that, and also nausea and sleeping disorders as well. States that allow of medical marijuana removed criminal penalties on the use, possession, and cultivation with patients who possess a written or oral recommendation. That's a very, very important and powerful definition there. So states that allow medical marijuana removed criminal penalties on the use, possession, and cultivation with patients who possess a written or oral recommendation. Now keep in mind, these are criminal penalties. In no way does this speak to employment purposes. So currently have 19 states that have medical marijuana laws. Those states are Alaska, Arizona, California, Colorado, Connecticut, Delaware, Washington, D.C., Hawaii, Maine, Massachusetts, Michigan, Montana, Nevada, New Jersey, New Mexico, Oregon, Rhode Island, Vermont, and finally Washington. And you can see those states shaded here. So each state has legalized medical marijuana usage for what they call qualified patients, a term that essentially each state has defined differently, of course. So states remove criminal penalties on the use and possession, cultivation of marijuana by patients. So these are patients that have gone to a medical doctor and received a recommendation. In Connecticut, the use of prescribed medical marijuana is permitted to alleviate symptoms of debilitating medical conditions. Alaska, for instance, possess written documentation from their physician advising that they might benefit from the medical use of marijuana. Colorado states possess written documentation from their physician affirming that he or she suffers from a debilitating condition and advising that they might benefit from the medical use of marijuana. So you see the descriptions here, and then Oregon, for instance, possess a signed recommendation from their physician saying that marijuana may mitigate his or her debilitating symptoms. So these states aren't stating that marijuana is a 100% cure for whatever ailment individuals will have. They're stating that the effects that marijuana has on individuals could aid them or could benefit them with regards to whatever medical conditions they may have. A very, very important section 16.6a of the Colorado law states that nothing in this section is intended to require an employer to permit or accommodate the use, consumption, possession, transfer, display, transportation, sale, or growing of marijuana in the workplace, or to the ability of the employer to have policies restricting the use of marijuana by employees. So this is verbiage straight from Colorado law, and keep in mind Colorado is one of the 2 states that legalize marijuana altogether. So essentially they're saying that based on their medical marijuana laws, in no way is it reflected or have anything to do with the workplace, the employer, or the employees. So yes, in fact, an employee or an applicant may have been prescribed medical marijuana, and they're protected under state law with regards to any criminal activity, possession of it, sale of it. However, once they want to become employed and processed with a company, they're not protected under any state law and surely not protected by any federal law. And again, if anyone does have questions, please utilize the chat feature in the lower right, and we'll go ahead and answer those at the end of the presentation. So moving along, federal government stance, Uncle Sam. So the DEA, the Drug Enforcement Agency, which is a federal agency, defines marijuana as properly categorized under Schedule 1 of the Controlled Substance Act. That's clear weight of the currently available evidence supports that this classification, including evidence that smoked marijuana has a high potential for abuse and also has no accepted medicinal value in the treatment in the United States. That's very, very powerful. It has no accepted medicinal value in the treatment of the U.S. So the federal government completely views marijuana as an illegal, illicit Schedule I drug. They do not see any medical benefit in it at all. And also evidence that there is a general lack of accepting safety for its use even under medical supervision. So basically they're saying that there's no way that you could regulate medical marijuana and in fact say 100% that each medical marijuana user is in fact using it for medical purposes. Again, marijuana for any use is illegal under federal law. Attorney General Holder issued guidelines on federal prosecutors on 10/19/2009, which he stated it will not be a priority to use federal resources to prosecute patients with serious illnesses or their caregivers who are complying with state laws on medical marijuana, but we will not tolerate drug traffickers who hide behind claims of compliance with state law to mask activities that are clearly illegal. What that's saying is the federal government is not going to actively pursue individuals who have medical marijuana licenses and purchase medical marijuana in compliance with state law. However, if you have individuals abusing the privileges of being able to grow or purchase medical marijuana in hopes of reselling it, in hopes of making money off of it, turning it into a drug enterprise, then the federal government will go ahead and investigate and probably prosecute those individuals. So the federal government's stance is pretty black and white, and that marijuana still, at the federal level, is illegal. Maintaining a drug-free workplace. Now this is kind of going into dealing with the employer directly. So maintaining a drug-free workplace, the employer's duty, employers really have the duty of ensuring that their employees can come to work and be completely free of any kind of drug use, alcohol, marijuana, cocaine, tobacco, alcohol, anything like that. An employee should be able to come to work and know that none of that will be around in the workplace. It promotes a safe workplace. It promotes a positive workplace. But you've got to have a complete no tolerance at all. Ensuring a drug-free workplace really does decrease liability. You have individuals that are not under the influence. Oh, excuse me. Sorry about that. So ensuring a drug-free workplace decreases liability. So it cuts down on accidents, which will cut down on money that companies must pay, workers' comp claims, insurance. So having a good drug-free workplace program really does benefit both the employer, the employee, the business in general. It's really a win-win for everyone. It also increases productivity, reduces accidents, absenteeism, and turnover. I was going to put statistics. There's a boatload of statistics out there on drug use directly reflected in absenteeism and tardiness and productivity. But I mean, it's pretty self-explanatory that an employee that is drug-free while at work really does perform better than employees that are under the influence, even if they are at work. Also, a huge plus with regards to maintaining a drug-free workplace is, better opportunity of winning large contracts. So when big entities, public utilities, cities, counties, states, federal government puts out, proposals, kind of value-added service that companies can put in their proposals is that, look, all of our employees, contractors are all, drug-free. We promote a drug-free workplace. It could be industry-specific, so manufacturing, aviation. I mean, these are certain industries that in no way should any employee be considered under the influence. So better opportunity winning contracts. You have a happy employee, which has a happy manager, which has a happy owner, and hopefully happy customers. You save money on workers' comp claims, and also, ensuring drug-free workplace decreases any kind of liability and safety issue. Drug testing program and policy. So we previously did a webinar specifically speaking to a drug screening program policy and best practices and what should be in the policy and really dove in to the crucial sections. So like any policy, it really does decrease any liability arising from discrimination claims. So, why was I had to submit to a drug test as opposed to office clerk? Therefore, I was terminated because I tested positive for drugs. Well, in the drug screening policy, you'll notice that office clerk doesn't have access to certain areas of the building that a warehouse manager was, which was the position you're applying for. So drug testing isn't required. What is required for that position is A, B, and C. So specifically spelling out why the company does drug tests, who's subjected to drug testing, when they will be drug tested is very, very important. So, for instance, when drug testing may be administered, pre-employment. That's pretty much the most common way that an employer conducts drug tests, is either part of the pre-employment or post-offer background screening process. A random test, especially businesses that are regulated by the Department of Transportation. They need to have a good random testing program where that individual drivers on a random basis is selected to submit to a drug test. Post-accident, if any of your employees got involved in an accident, it's a good idea to drug test them afterwards to see if that may be a contributing factor. Reasonable suspicion. If you feel that the individual is giving off alert signals that they could be under the influence, definitely have verbiage in your policy that states that you reserve the right to drug test them based on reasonable suspicion. Also return to work. Individuals go off on medical leave, go off on a workers' comp claim, they just leave the company and come back. Definitely recommend drug testing them once they return back to work. And identify specific safety positions. So like I mentioned, specifically state these positions are subjected to drug testing because of the sensitivity and responsibility that the individual will have. Also, conduct different types of drug screening. So of course the most common is urine drug screen. So we do, majority of the drug testing we do is our urine. However, we do have clients that are required to do either a hair follicle test or a saliva test. So there are different ways of administering the test as well. So if an individual says, sorry, I have a problem, urinating, to do the urinalysis test. Well, there's other ways about going about it. You can do hair follicle, saliva testing, and even blood testing is available to see if the individual is under the or impaired by any drugs. Posting signs. We always kind of mention this in all the webinars we do. Post signs stating that your company conducts employment drug screening on all new hires. I guarantee you this will definitely deter less than desirable job applicants that may want to process with your company. Cut down on time, cut down on money. Just go ahead and post those signs. We'll be more than happy to issue signs to our clients. That's not a problem, but it's a very, very useful tool that employers can use. Synthetic marijuana. This is a very, very new and dangerous drug that individuals are trying. Essentially, it's considered fake marijuana, and it's otherwise known as K2 or spice. So it is a marijuana herbal replacement. Most important thing is that it will not trigger a positive test of cannabinoids or the THC content that is in marijuana. It's not organic at all. It's not grown. It's either manufactured in a lab or on a kitchen table, just like methamphetamine or heroin would be. So the finished product looks like crushed grass. It is considered a designer drug, like ecstasy, like oxycodone. It's not considered, a seedy drug, stereotypical drug like methamphetamine or cocaine or heroin would even be. So the synthetic cannabinoids applied to or sprayed on a mixture of herbs. So it's essentially a spray that was created by John W. Huffman, who was a chemistry professor at Clemson University in the early 90s. And he even is on record as saying that if any individual uses this synthetic spray essentially to get high, would be foolish and is using it for all the wrong reasons. At one time, it was legitimately used as a plant growth product, and that's how it's marketing now as plant food. So it kind of goes by plant food, kind of go under the radar, but essentially it is a synthetic drug, and it's very, very dangerous. Spice does not cause a positive drug test for cannabis on a regular drug testing, so it is important that if you are going to test these individuals, they do a lab-based test, a urine test going into a Quest lab or any kind of lab, not just doing an on-site dipstick test or anything quick or instant. It will not pick up any cannabinoids, which are considered marijuana metabolites. Some of the symptoms that you would know in individuals on spice is they have increased agitation and vomiting persists. If they abuse the drug on a regular basis, they can precipitate psychosis, and in some cases that can be prolonged. And there is a case out there where a young adult actually committed suicide an hour after taking spice because of the psychosis or the hallucinogens that consist in the drug. Several states independently passed acts making it illegal under state law to possess or be under the influence of spice. So this is it's a very, very serious drug. It is available, just like anything online. Any individual could go ahead and purchase this synthetic drug, but essentially individuals are doing this to mask any kind of positive test. So make sure you have a robust drug screening program, and that you're probably doing a 10-panel test or testing for the most drugs available or that your vendor would provide. Okay, now we're going to go into case law. So Ross versus Waging Wire Telecommunications. This was a court case out of California Federal District Court, and addresses the conflict between California's Compassionate Act law, which was one of the very first medical marijuana laws, and federal law. And again, federal law, it is illegal to possess marijuana even with a prescription. So Raging Wire Telecommunications terminated an employee for testing positive on an employment drug screen. The employee claimed that they had a prescription from a medical doctor due to chronic back pain, and Raging Wire discriminated against them due to the use of medical marijuana. So an employee was prescribed medical marijuana, or I'm sorry, has a recommendation for medical marijuana due to chronic back pain, and obviously was impaired or under the influence while at work, and this came out in an employment drug test. Court ruled that Raging Wire's decision to terminate plaintiff was not illegal. Under California law, an employer may require pre-employment drug tests and take illegal drug use into consideration in making an employment decision. So again, under California law, an employer may require pre-employment drug tests and take illegal drug use into consideration in making an employment decision. The court also ruled that no state law could completely legalize marijuana for medical purposes because the drug remains illegal under federal law. And that's very important there. So as long as the feds recognize and view marijuana as an illegal drug, it'll continue to remain illegal under federal law. California voters merely exempted medical users and their primary caregivers from criminal liability under two specifically designated state statutes. Nothing in the text or history of the Compassionate Use Act that California has suggests the voters intended the measure to address the respective rights and obligations of employers and employees. That's stating that this California law was specifically put in place to aid individuals that have medical conditions that would benefit from medical marijuana. In no way was this law created to protect employees from employers using drug testing in making an employment decision. That's very, very important. Washington and Colorado. As many of you know, last November, these were the two states that legalized the possession of marijuana up to 28.5 grams for recreational use. So you do not have to have a medical marijuana license in these states to buy or use marijuana. State licensed stores tax the purchase of marijuana exactly how alcohol is nationwide. You could go to state-ran stores to purchase marijuana, and it is taxed. It is taxed from the growers to the distributors all the way to the retailers. So these states are making a lot of money based on these new laws that they enacted. These laws will, however, put both states in further conflict with the federal government. Federal government's not going to budge on their stance on marijuana. So again, it's putting more of a disconnect between the state and the federal government. Employers in Colorado and Washington, they still use drug testing as part of the background screening process. Again, just because it is legal to possess marijuana, you cannot be impaired or under the influence at work, just like alcohol. You know, individuals can't come to work and get drunk at lunch or at their desk just because they have an ID to purchase alcohol. So it still is illegal to be under the influence at work, and employers can make an employment decision on that. If you do business in these states, the 19 states that we talked about, I really recommend having an ironclad drug screening policy just to protect your business and your employees. It's very, very important to identify if you do business in a state that does have medical marijuana laws. Moving along, current trends. Currently, there was a settlement brought on by the EEOC, Equal Employment Opportunity Commission, against Dayton Superior Corporation. Dayton Superior Corporation was ordered to pay $50,000 to settle a disability discrimination lawsuit. The lawsuit claimed that Dayton Superior discriminated against an employee who was prescribed medication for bipolar disorder. While at work, the employee suffered an adverse reaction to her medication, and Dayton Superior required her to submit to a drug test. Although the test only revealed the medication prescribed to her, Dayton Superior terminated her due to the results. So when individuals go in or employees go in for drug tests, it's always important for them to let the lab technician who's administering the drug test know if they're under any kind of medication that could essentially show up in a drug test. So here, obviously, an employee was prescribed medication for bipolar disorder that they had from a medical doctor, and that medication did trigger a positive test. However, again, that's communicated to the lab. The lab communicates that to the MRO, their medical review officer that views the results, and that should be communicated to the employer. Dayton Superior still recklessly terminated the employee due to that positive test. And the court ruled that, or the EEOC ruled that making employment decisions of the basis of stereotypical assumptions about disability-based medication is one of the problems, and the ADA, the Americans with Disability Act, was designed to combat. So Dayton Superior Corporation was held liable for terminating an employee for having tested positive for actual medication that she was prescribed by a medical doctor specifically for her disorder, and this was disclosed as well. Prevention. Providing and promoting a safe, drug-free workplace. So once making a commitment, employers must set goals and objectives. Accountability must be established and specialized policies developed. Those policies should prohibit the use, sale, and possession of all controlled substances and alcohol on company time or property. Drug testing and fitness for duty applications should also be incorporated. Do not use terms such as under the influence that imply some legal standard. Instead, consider using terms such as impaired or the presence of any detectable quantity. Have all policies and procedures reviewed, obviously, by legal counsel. Setting clear and meaningful objectives. Employers should also better screen applicants by testing for drugs, conducting in-depth background investigation, and using trained interviewers. And employers can avoid hiring mistakes and create a safer workplace. Nothing worse than hiring someone who said they were one thing and ended up being something else. Assigning responsibility. Obviously, assign who would be responsible for managing and processing your employee drug screening program. Formulating a comprehensive policy. So we talked about the policy and what the value is in having a background screening policy. Obviously, communicating the policy to the employees, having it in a handbook, having them sign off, acknowledging that they did read the policy and they understand everything that goes into it. Enforcing the policy. Obviously, the policy is only good if it is enforced. So having drug screening programs, obviously taking adverse action on individuals that test positive for drug testing is very important. Providing education and training. We have a training division, compliance training group, that actually has a substance abuse awareness training module. where employees can take training via e-learning on drug abuse. And again, this helps if you have any kind of lawsuits or any employee stating that, hey, I didn't know we weren't allowed to use drugs, or for whatever reason. It's very, very good to continuing to educate and train your employees. And auditing the program as well, making sure that it is working. Again, training and education are also very important in creating a safe and drug-free workplace. Lastly, recommendations. So obviously having a comprehensive drug screening policy, be aware of your state's medical marijuana laws is very, very important. As well as understand the difference between federal law and state law. I think we pretty much explained what the state's stance is and what the federal government stance is with regards to marijuana use. From the Colorado Courts of Appeal, they stated that in no way, while we agree that general purpose is to keep an employer's proverbial nose out of an employee's off-site, off-hour business, we can find no legislative intent to extend employment protection to those engaged in activities that violate federal law. It is still a very, very gray area, and laws can change in a matter of days. So we have a monthly newsletter that we send out to all of our clients, just keeping them updated on new laws, on new case law, kind of tips that they can do to better streamline their drug screening process or their background screening process, whatever they would like. So that's actually all that I have. I'd be more than happy to take questions and answers now. So if anyone would like to utilize the chat feature in the lower right of the box and go ahead and type in their question, will be fine. If a question comes up later, please, by all means, either email me or place a phone call. I'd love to speak to you about this. I really do anticipate kind of doing a part 2 to this. Kind of want to see how the rest of the year goes. And like I mentioned at the beginning of the presentation, if anyone has any kind of ideas or would like to hear something on social media, anything that piques your interest that you would like to have a webinar on, we could definitely tailor it and see if there is an interest and put it down on the calendar. Like I mentioned, this presentation will be available on our website next week, so I would check back next Thursday. If anyone would like a copy of the PowerPoint presentation, I could definitely provide that to you. That's not a problem. Here's my contact information here. So if anyone wants to reach me, I'm available usually in the office 6 a.m. to about 4 p.m. Pacific Standard Time. My contact information here. Would really like to educate anyone that wants to know about background checks and employment drug screening. So doesn't look like there are any questions. There was a lot of information. I'm sure questions will come up later on, so please reach out to me via email or phone call, and I'll be more than happy to talk to you, be able to give you guidance on drug screening policies and best practices. So I do appreciate all of you taking the time out to listen to this presentation. I do anticipate this will be one of many. So if there's anyone that doesn't have any questions, I guess that's the end of the presentation. But I do appreciate all of you taking time out of your busy schedule to view this webinar. And again, if you have any questions, don't hesitate to give me a call. I'll go ahead and leave this up here for now. So if anyone does have any questions, please don't hesitate to utilize that chat feature in the lower right. Just go ahead and click on the plus next to chat, and you go ahead and type in your questions. If anyone doesn't have any questions, I do appreciate you again taking the time out. You have a wonderful day.